Hi, everyone. Thank you so much for joining us today for our event on adequate reparation in the future LBI, the example of mining disasters. We also want to extend an appreciation to our panelists today who are coming from all over the world and are staying up very late in the case of Elizabeth. So this event is taking place on the margins of the Intergovernmental Working Group session on transnational corporations and human rights. Although the negotiations on the last draft have begun as of yesterday, we are still early in the discussions and have not yet reached the articles more directly on reparations. Hopefully today, through our discussions on mining disasters in Brazil and the Philippines and the status of reparation agreements there, we can perhaps have more substantive proposals for this week to ensure the rights of victims and impacted communities are guaranteed. We have three main speakers today who will have 10 minutes each to speak. We will then have a question and answer period. Because of the limited amount of time that we have, only 1 hour, we will be placing the bios of each speaker on our website. And if you require any more questions, please feel free to ask us also during the Q&A. So first we have Pedro Andrade, hopefully I said that correctly, who is an environmental lawyer at the UFMG Institute and works with and provides technical assistance to affected communities in Brumadinho from the Valley disaster. Pedro?
Hello, everyone. Just a second. Good afternoon. Good evening to everyone. First of all, I'd like to thank Marya, Farah, and Franciscans International for the opportunity to participate on the side panel. It's a pleasure to be here. My name is Pedro Andrade. For the past few years, I have been working with the victims of one of the major dam break disasters in Brazil, the Brumadinho dam break from the corporation Vale SA. And today, I would like to speak about what I call an architecture of impunity and how the public governments from the Brazilian institutions that have been created to address these both of the great major disasters in Brazil have actually hindered just satisfaction for the victims of the disasters in Brazil. I'd like to divide my presentation in three parts. First, a brief overview of the two disasters, and how this, what we call the public governance framework, was created, and how the Brazilian institutions have handled both of these cases, specifically in the judiciary branch of the Brazilian institutions. And finally, how the lessons from Mariana and Brumadinho can help us to better understand the current draft and analyze the current draft of the binding treaty. First, I will not digress too much on both of these cases. I think that they are very well known around the world. But just to illustrate, I would like to bring this picture here. And I think that most people know that both of these disasters are the two greatest environmental disasters in the entire of Brazilian history. And when we look at this picture, although they are separated by 4 years of timeline, they are strangely similar. And I believe that the fact that they are so similar is because the Brazilian institutions have failed to actually create adequate prevention and mitigation and satisfaction and reparation for these crimes. First of all, I would like to address some of these problems here in Brazil. Like I said, they are the two major disasters, but I will not linger much on the facts. I would like just to bring some pictures for us to illustrate this occurrence. This is the municipality of Bento Rodrigues, in the village of Bento Rodrigues in Brazil. Both of these disasters have affected more than 1 million people in Brazil and thousands of kilometers of both the rivers of the Doce and Paraopeba River basin in Brazil. Many deaths and internally displaced persons in Brazil. Like I said, they are the two greatest environmental disasters in Brazil, and up to this day, we are not fully aware of the long-term impacts of these disasters in the Brazilian environment. This is, like I said, the Beto Rodrigues village in Brazil. This is when the mud tailings have actually reached the sea. These pictures could be seen actually from space. And this is the partially destructed Córrego do Feijão village in Brazil, which was also destructed in 2019 disaster. And why do I call, in reference of Garcia Marquez, that this disaster, especially specifically the one of 2019, is a disaster announcement? Because, like I said, both of these pictures that I have brought, they are strangely similar. Because the fact is that we could have prevented the second one from occurring, but we haven't. In Brazil, we have not learned from the previous mistake, especially regarding the flexibilization of environmental regulations. In the aftermath of the Mariana disaster of 2015, Brazilian institutions, the legislators, have not actually tightened up environmental regulations, but they have actually facilitated mining license to be promulgated here in Brazil. And still up to this day, the victims have not received adequate reparation and satisfaction for their crimes. Therefore, we can see that the flexibilization of environmental license and the lack of reparation, mitigation, and prevention has led to this crime occurring again in Brazil. But one of the major motives of the repetition of the disaster in Brazil is what we call the subject of this presentation, which is the public governance framework. In other words, how the Brazilian institutions have handled these cases. And I believe this is also one of the main problems that we have faced. To understand this public governance framework, we have to understand what we call in Brazilian legal lawsuits the procedural substitution. In Brazil, there are many institutions, public institutions, that can actually substitute and subrogate on the rights of the victims of environmental disasters and to file large class actions that can actually benefit all the victims of the disasters. And this is one institution that can actually contribute to the access of justice, since in Brazil, many of these victims are actually living in poor communities and do not have access to legal counsel. So it is, in one way, a contribution to the access of justice. However, in practice, it also means that these institutions can actually carry on the process without any kind of participation of the victims. They can actually sign reparation agreements without the victims. And this is actually what has happened in Brazil more recently. An example of some institutions that can actually file this class action lawsuit, which we call the class action legitimates, is, for example, the Public Attorney Office, the Public Defender's Office, the state and federal attorneys of the executive branch, and other NGO organizations. And these institutions can be both from the federal government and from state institutions. Since we have this kind of procedural process in Brazil that these institutions can actually substitute the victims, what has happened in Brazil is that we have too many class action legitimates. In the Mariana disasters, what occurred was that we had countless class action lawsuits that were filed, creating a very high legal uncertainty due to the risk of conflicting decisions. This is what we have called the competition between the legitimates. And this has led exactly to the creation of what we call the public governance framework, which aims to avoid the proliferation of lawsuits. This was established in the end of the Mariana disasters. And in the case of Marinduque, since the beginning, it's a situation where what we call the multi-level governance framework, which means that the public institutions afterwards, they decided to stop the proliferation of lawsuits and to start to cooperate and reach consensual agreements, even with the perpetrators, in this case, the corporations. And I believe that this public governance framework is one of the main causes of the impunity of the perpetrators and the lack of just satisfaction for the victims. I have listed here some of the problems of this governance framework. First, to avoid litigation and the proliferation of lawsuits, the Brazilian institutions tend to seek a consensual agreement with the perpetrators at all costs. These agreements usually fall short on the minimum justice requirements for the victim's just satisfaction. It also raises the company's bargaining power, since the company can threaten to judicialize and to file other lawsuits and to appeal from court decisions. This also tends to lead the prosecutors of the cases to try to reach a mutual concession agreement with the corporations. The prosecutors also tend to cooperate with other co-perpetrators, such as the very own executive branch of Brazil. The executive branch, which is actually partially responsible for these environmental disasters, since it is the one who provides this environmental license and has the duty to fiscalize these dams of these corporations. But since the executive branch is also one of the legitimates to file a class action, the prosecutors tend to cooperate with them to avoid the proliferation of lawsuits. And this has culminated with in this year, I think that this is very well known, with a major collective reparation agreement that was signed this year in February 4 by the Public Attorney Office and the corporation Vale S.A. It is important to notice that the victims were forbidden to participate on these negotiations. And also all the files and procedures of these negotiations were placed on strict confidentiality under the argument of the secrecy of the mediation process. And after months of secret negotiations, a very big agreement was announced that regulated not only collective damage, but also environmental reparation. And this is one of the main problems that we have, which is the lack of participation, which is I will focus now regarding the current draft of the binding treaty. So what lessons can we learn from this process, which was a process that involved the substitution of the victims and the negotiation of agreements without the participation of the victims? The first lesson from Orellana and Brumadinho is that there can be no reparation without participation. Closed-door negotiations and confidential agreements without the participation of the victims, such as has occurred in Brumadinho, tend to favor local political interests and interfere with reparation. Regarding the local political interests, I'm speaking about the executive branch, which is also one of the cooperators of the Public Attorney Office. Second lesson, there should be limits to negotiation solutions and to environmental mediation. The fact that in Brazil, the government authorities in the current governance system tend to try to reach consensus at all costs is one of with the corporation, it can lead to unfair agreements and to the impunity of the perpetrators. The third lesson is that there should be no statutory limitations to reparations. The Brazilian statutory limitation to reparation, which is currently 3 years, is one of the main causes that people, usually the victims, try to reach an agreement, trying to avoid the prescription of the reparation obligations by the corporation. And also due to the time that these lawsuits take in Brazilian judiciary branch and the complexity of the major environmental disasters, this also leads to this kind of big collective agreements, such as has occurred in this case in Brumadinho. So like I say here, time is on their side, and on their side, the corporation side. The longer the process takes, the better for the corporation. And the Article 10 of the current draft also speaks a little bit about this statutory limitation, which are also one of the issues that we have to address, which was one of the main causes of disagreements in Brazil. And the fourth lesson, there should be, I think I will skip this lesson because I was planning to speak this on other lecture. So I will focus on the right of participation. The right of participation is...
Sorry, Pedro, if you could finish in the next 2 minutes,
sure.
Please.
The right of participation is prescribed in many international treaties and declarations. And in the current draft of the binding treaty, you can see it on the Article 4. However, Article 4 doesn't have any kind of disposition regarding the right of the victims to participation in the negotiation of agreements or collective agreement negotiations. And Article 7 states that the state parties should guarantee the rights of the victims to be heard in all stages of the procedure. But my question is, in concluding, is this enough? Are these dispositions enough to prevent what has occurred in Brumadinho, which is a huge agreement of reparation without the participation of the victims? And I believe that it is not enough. I think we need to have other kind of considerations. For example, the necessary publicity of all negotiation files and procedures regarding environmental disasters and environmental negotiation. The right of the victims to be a part of this negotiation and to be heard in all kinds of mediation process, and the right of the victims of prior consultation regarding their rights of any kind of environmental remediation or restoration. Thank you very much.
Thanks so much, Pedro. And I'm sorry we don't have
Sure.
more time, because your lessons learned were very interesting and useful for the negotiations. And I think also your point on the public governance framework and the cooperation or entanglements really between businesses and government, and how that leads to a lack of rights for victims and future disasters is really important, something that we see in other contexts as well. Next, we have Elizabeth Manggol. She's the Executive Secretary and Secretariat Head of the Marinduque Council for Environmental Concerns. Elizabeth?
Good evening. Thank you for the opportunity to hear the experience of Marinduque Island from disastrous copper mining operations. Let's hear the history of the copper mine disaster. In 1969, copper started operations in Marinduque Island, Philippines, with the copper mine in Mount Tapian, the first mining, open pit mining. It was co-owned by Canadian firm Placerdom with 39.9% stake at Copper, and it is listed in Toronto Stock Exchange. There is also a government share held under the dictatorial administration of Ferdinand Marcos, and this personal share also held by Marcos behind Front Prony Corporations. And then in 2006, Placerdom was purchased by Barrick Gold. The first mining disaster was happened during the dumping of mine tailings in Calancan Bay from 1975 to mid-1991. It was happened during the first 3 years of operation. Disposal of mine waste was on land. They disposed the mine tailings in the San Antonio tailings pan. They only stopped the dumping in San Antonio tailings pan when they discovered that there's a lot of huge minerals in there, so they stopped the operation there. And then in 1975, Copper started dumping its mine tailings into Calancan Bay at the rate of 2.5 tons per second, estimated aggregate amount of 200 million tons of mine tailings into Calancan Bay, until the Tapian Pit Reserve was depleted in 1990. And then the second mining disaster is the collapse of the Magila-Gila siltation dam and the demise of the Mabog River that was happened on December 6, 1993. Copper moved its operation in the San Antonio copper mine 3 kilometers north of the Mount Tapian site. And then the Tapian site commissioned as dumping site. Then, despite of public opposition, in 1991, earthen dam was built at the Magila-Gila Creek, the headwater of the river, to contain the tailings accumulating at the open pit. And on December 6, 1993, after a heavy but unusual rainfall, the Magila-Gila Dam was breached, inundating the towns and submerging vast tracts of farmland with contaminated sludge. Actually, there was 2 children drowned in the disaster, and after 15 years, Mogpog River was declared as biologically dead by the Department of Environment and Natural Resources. And then the third history was the bursting of the Tapian Pit and contamination of the Buwak River system on March 24, 1996. It was happened because of the concrete plug sealing the Tapian Pit tunnel from the Buwak River ruptured. It was the secret drainage tunnel then that was burst. It discharged 2.2 to 3 million tons of mine waste to the 26-kilometer long Buwak River at a rate of 5 to 10 cubic meters per second. And then flash flood submerged villagers under 6 feet of floodwater, silted vital river channels with toxic mine tailings. And Placerdom Technical Services Limited, subsidiary of Placerdom Incorporated, established to clean up the mine tailings in the Buwak River. And then it so happened that 1997, Placerdom divested from Marcopper by involvement of Cayman Island MR Holdings Company. That's why when I happened to see in the mine site in 1997, I saw that all the properties of Marcopper was posted. This is owned by MR Holdings already, with premise to take responsibility for the cleanup and compensations. But in 2021 agreement with between Marcopper takes on the responsibility. This is the open pit mine, the upper and lower Makulapnit Dam, and also the open pit, and the pictures of mine site. And of course, the impact that experienced by the communities, effects suffered from toxic mine tailings, the contamination of the river system, public health hazards, damage to livelihood, contaminated farmlands, livestock, damage to flora and fauna, natural resources, including marine life. Actually, even birds also is contaminated with heavy metal contamination. Residents and fisher folks have no choice but to live off the land and the sea for sustenance, now suffer from extreme poverty, strange chronic illnesses, and premature deaths due to exposure to next. And the consumption of products heavily contaminated with toxic metal. Actually, in the recent study of the Mapua Institute, there are 5 vegetables which is contaminated by heavy metals, and even our waters, fresh water here is contaminated with heavy metals, but still used by the communities. And these are those pictures of the Tapian Pit, which look like this, the same. And this is the Kalangan Bay. And there are lots of local suits filed against the mining companies. One is the Rita Natal et al. Versus Marcopper, filed in 2001. It is a quasi-delic and tort versus Marcopper and Placerdom for the collapse of the Magila-Gila Siltation Dam and the demise of the Mogpog River. It is ongoing now. The hearing is still ongoing at the Provincial Trial Court in Marinduque. And in 2005, Placerdom impaned the authority of the Philippine courts to exercise jurisdiction upon each person because no address could be supplied for Placerdom, and Placerdom Technical Services would not be considered its resident agent because they already divested their shares with Marcopper. Provincial Government of Marinduque versus Placerdom Incorporated and Barrick Gold Corporation, filed in 2005. This against Placerdom because the Nevada District Court for Public Health injuries and destruction of the natural, ecological, and wildlife, and extreme poverty suffered by the communities. Placerdom subsidiaries own mining operation. That is the point of the provincial government why they filed the case in Nevada. It so happened that it was dismissed by the Supreme Court of Nevada on the issue of jurisdiction, but not on the merits of the case. Another case is the Kalankan Bay case filed by 108 fisher folks in 2008. It is an abatement case filed by the Kalankan Bay fisher folks versus Placerdom and Marcopper. It is the complaint against alleged injuries to health and economic damages to the local fisheries resulting from the disposal of mine tailings from the Marcopper mine. But the case was dismissed against Placerdom on the ground of lack of personal jurisdiction because Placerdom and Barrick are non-resident foreign corporations. As I said, they divested already their shares with Marcopper. Another suit is Perilia and De Luna, Placerdom and Barrick Gold filed in 2008. It is for abatement of nuisance and damages seeking to rehabilitate the pollution in Kalankan Bay and the Buak and Mogpog River, as well as the surrounding areas thereof. Summons were served on Placerdom and Barrick via the Canadian Embassy. But without submitting themselves to the jurisdiction of the court, Barrick has filed a motion to dismiss. Another case is the writ of kalikasan filed in 2011, filed by the three mining affected individuals pending at the Court of Appeals in Manila. It is in violation of their constitutional right to a balanced and healthful ecology as a result of the discharge of tailings into Kalankan Bay. Barrick Gold and Placerdom impan and the jurisdiction or question the jurisdiction of the Philippine courts by allegedly Placerdom was merely an indirect minority stockholder of Marcopper and thus could not be considered to be doing business in the Philippines. After 30 years of mining operation, that's the answer of Placerdom. That's why there's a need to bind transnational corporation. It is an opportunity for us to have other options or other mechanism because we have done a lot. We have organizing, capacity building, meta-legal, and legal advocacy, legal strategies, but there's elusive justice for the mining affected communities. But the communities have not lacked in their efforts to hold Placerdom and Barrick Gold accountable, but are constantly met with legal challenges at the local and national level. For instance, postponement of hearing, dismissal of the case, and the long cases happens to suffer the victims because they are growing older and passing away because of the old case. The Philippine courts, please go back again. The Philippine courts are challenged to acquire jurisdiction over Placerdom and Barrick Gold, the transnational mining corporations in general. Meantime, the impacts of the mining operations and disaster continue to be suffered by the communities because the impact is continuing. The damage is continuing. Next, please. And there's the right of victims under the Article 4 on rights of victims. The other one is the Article 7, Act access to remedy, then the Article 8 legal liability, and then the Article 9 adjudicative jurisdiction. The affected communities should be able to seek redress and justice. It's been elusive after the 30 years mining operation and after the irreparable damages. There's elusive justice for mining affected communities. It should be established direct legal obligations for the transnational mining corporations in the home and host country, and then the solidarity responsibility to cover all activities along the value chain of the transnational mining corporations. And they should voluntarily submission of the transnational corporations on their responsibilities have failed. There must be obligated and ensured to protect the right of affected communities.
Sorry, Elizabeth, could you finish in the next minute or two, please?
Yeah. We have a statement here. If you can read this fast. And the Article 4 in the proposed text for a legally binding instrument on the rights of victims is of crucial importance to us, communities that have been severely impacted by corporate abuses and violations, and who for many years have continued the struggle for accountability and justice. We support the demand of the global campaign and other networks to expand the definition to include rights of affected communities. The treaty should recognize that when we speak of victims of corporate abuses and rights violation, that we should consider the right of all individuals and communities threatened or affected by corporate harm, even if they have not yet been declared as victims. We challenge the view advanced by big businesses that a person or a community only becomes a victim after the alleged harm is proven in court. This view is a clear obstacle to affected communities seeking to access remedy and justice. We believe that the treaty should make it easier for affected communities to gain access to adequate, timely, and effective remedy and access to justice. The burden should be on corporations who have inflicted the harm and not on the victims of these abuses and violations. From the Asia Task Force, thank you very much.
Thank you so much, Elizabeth. The history of all of the different cases and claims that were made in different jurisdictions was very interesting and also frustrating to hear, but it was inspiring also to hear that the community is still persistent in their pursuit of justice. Thank you. Next, we have Marcos Orellana, who is the UN Special Rapporteur on Toxic and Human Rights. Marcos.
Thank you very much, Marya, and many thanks to Franciscans International for this space. I'm very pleased to join this panel, and in 10 minutes I wish to share some thoughts about the extent to which the current draft under negotiation addresses some of the key challenges in regards to access to remedies, specifically on environmental issues. I'm also pleased that the comments that I submitted to the process last year, several of which have been taken into account. You may have seen a statement that several special rapporteurs put out some days ago, encouraging states to engage negotiations. That statement is strong on questions of prevention, of due diligence and reparations. And I put the emphasis on reparations because it is one of the driving forces in the negotiation of the TNC treaty, the imperative to end impunity. So a couple reflections. The first one, let's recall that on the 8th of October, last session of the Council, the Human Rights Council, recognized, overdue, but very welcome, the right to a clean, safe, healthy, and sustainable environment. This should put to rest any arguments that environmental rights are not involved in the scope of the treaty. The treaty negotiations can very well and should most definitely address environmental rights and environmental issues. A second reflection is on challenges to access to remedies. And there's several points that I wish to make here. First of all, on the burden of proof. The general rule in international law, if it could be succinctly stated, is that the party who alleges a fact bears the responsibility, the burden of proving it. Now, that rule may not be very well suited in dealing with the asymmetries apparent in litigation between victims of human rights abuse and resource-endowed transnational corporations. That's where, for example, the Escazú agreement concluded recently in Latin America and the Caribbean and already in force on access rights, including access to justice, contemplates the rule of the dynamic burden of proof. And so this is a rule that has emerged in the jurisprudence of several Latin American states, whereby the party in litigation that is best placed to prove a fact bears the burden. And often it is the corporation that holds the information that bears the burden. So that's the first point about the burden of proof. Now, the draft in Article 7.5 contemplates the possibility of allowing judges, and I'm quoting here, to reverse the burden of proof in appropriate cases to fulfill the victim's right to access to remedy. And I think this is a welcome addition. Now, it does open the question of which are appropriate cases, and that's where the draft could make further contributions to clarifying this, and so perhaps it should more explicitly address and refer to the precautionary principle in regards to the transfer of the burden. There's much that could be said about negligence as well in terms of the burden of proof and points about strict liability, but I think for the sake of time, perhaps I'll just gloss over this. Maybe we can come back to it on the Q&A. I do want to speak to the point about evidence. The draft speaks of evidence only in regards to mutual assistance, but it does not address rules of evidence, and it does not address a key problem that we're observing in litigation against powerful corporations, which is the advent or emergence of what have been called product defense firms. So these are consultants and firms that specialize in fabricating doubt and uncertainty. This was one of the points that I elaborated on when I presented my report on the right to science to the Human Rights Council a few weeks ago now. Now, the draft should, I would say, address the questions of mercenary scientists coming into litigation with fabricated reports that put a very high burden on victims to be able to present scientific studies of general application that could sway courts. So that in terms of evidence. I'm going quick because time is very tight. On statute of limitations, against many jurisdictions, count the prescription, the statute of limitations from the moment of any negligent act. Then again, it comes to the question of negligence. But in the context of exposure to toxics, latency in the manifestation of harm, uncertainties, they may take years, if not decades, for harm to be manifest. And so the time when any statute of limitations should be counted should set aside the negligent act. It should look at, it should take a rights-based approach and the vantage point of the victims. The moment when victims, for example, learned about the harm or the harm was manifest. We explored several of these issues in the context of the Aarhus Convention Access to Justice issue in the most recent meeting of the parties, in the context of the Arica case. The draft treaty talks about, and here I quote again, or when the harm may be identifiable only after a long period of time. When it comes to statute of limitations, this is Article 10.2 draft. Now that formula could work, perhaps it could be improved, but it could work. So there's improvement there. On legal fees, just referred to the Arica case. So this case involves the responsibilities of Boliden, a giant Swedish company that transferred about 20,000 tons of hazardous waste and arranged for them to be dumped in Arica, in northern Chile, in the Atacama Desert. In the Swedish legal system, the loser pays. And so the victims, which had incorporated a vehicle to bring their claims, went bankrupt because they couldn't pay for the legal fees. The company presented a complaint against the lawyers, or at least two of the three lawyers, to the ethics board. And the ethics board, in a decision that came out last week or the week before, reprimanded the lawyers for arranging this vehicle to present claims, which meant that the legal fees could not be collected. So this is looking at reality from the perspective of the company again. And what about a rights-based approach, where the victims take precedence? So here we see in the draft Article 7.4 that it talks about, and I quote again, court fees and rules concerning allocation of legal costs do not place an unfair and unreasonable burden on victims or become a barrier to commencing proceedings. Now, I would say this is, again, a step forward, but again, unfair and unreasonable burden, they are very open texture terms, and they can be used as loopholes, or they can lead to additional litigation of issues. One last point that I wish to make on challenges on access to remedies is dissolution or exit. Recently sent a communication to the government of Peru, together with the Special Rapporteur on Indigenous Peoples' Rights, regarding what is going on in Lot 192 and the exit of Plus Petrol, that for many years operated the site. And the company, arguably to avoid legal liability, decided to dissolve. Now, it has been documented that between 2000 and 2009, 1669 million, so that's 1,669 million of barrels of production water, so these are toxic wastes, were dumped by the company in its operation into the rivers. What's the liability for that? Where's responsibility? The draft in Article 8.5 speaks about the duty to maintain financial security, such as insurance bonds or financial guarantees, to cover potential claims of compensation. I would say that that's a step forward and should definitely be maintained. Another point of reflection is on access to adequate reparations, including compensations. There's much that could be said here. I see that I have 2 minutes left, but I want to point out a couple of things. One, in the antecedents of human rights law, if we look at the international law on diplomatic protection, which is still alive and in some parts doing well, some would say, there's no obligation of the state to give any compensation to the actual victims of an international wrong. The state, as it espouses a claim, can keep the funds and monies received. And that we're seeing in lump sum arrangements. I think Pedro Andrade spoke about this, that are concluded between state offices and corporations in respect of large, massive situations involving harm. We can see that also in the Oil Pollution Fund established under the International Maritime Organization, where there's no obligation of the state to give money to the victims I am actually in Mauritius doing a country mission, and big part of this investigation has centered on the impacts of the MV Wakashio last year and impacts on fishers and others. So a couple of things on this. One is, at times, these lump sum agreements, there are no clear distribution arrangements for the, there are no clear arrangements for the distribution of benefits, but what's perhaps even more problematic is that the settlement of cases outside court, court sanctioned often, they are often secret in that evidence involving toxics is kept from the public domain. And this is incompatible with the right to science. It deprives society, deprives other victims from scientific evidence that is sometimes key to proving a case. And so that the treaty should address that. There's a gap there. Information regarding scientific evidence on exposure should never be kept confidential in a lump sum agreement. There's a lot that could be said about class action lawsuits. I think I've completed my time, so I will only conclude by saying that the treaty, the draft treaty on transnational corporations, I would say is making good progress, but there's still much more that needs to be done. Thank you, Marya, and I'm happy to take any questions.
Thanks so much, Marcos, for your intervention. I think for all of us that are in Geneva now for the session, you provided some extraordinarily useful inputs, and I think following the presentations by Pedro and Elizabeth, really highlighting also the burden that's placed on affected communities to bring a claim and even to have a successful judgment. So thank you again. Before we get to the Q&A, I am hoping to have just a maybe short intervention from Catherine Kuhlman, who is from Mining Watch Canada, and she would maybe hopefully provide some lessons learned and examples in terms of national legislation and the need also for a treaty. Catherine?
Yes, so thank you very much to the organizers and the panelists of this very important panel. I've been asked specifically to speak to efforts that are underway by civil society in countries like Canada, and particularly being led by European countries to establish national legislation that will create stronger accountability for our multinationals that are headquartered in our countries. So Canada's mining industry has left a terrible legacy in places like Marinduque, which we heard about from Beth, but not only there, around the world, and continues to cause really serious human rights and environmental harm through its operations, and always supported by the government of Canada. So for this reason, civil society in Canada is pushing for legislation that will mandate human rights and environmental due diligence. This will apply to all parent companies headquartered in Canada, as well as to all of their global subsidiaries. So some of the problems that we've been hearing about the difficulty in holding a parent company to account, as Beth's presentation was clear, for harm done by its subsidiary would be addressed by this legislation. The point of the legislation is to enhance, first of all, the prevention of harm up front through requirements around carrying out human rights and environmental due diligence, reporting on that yearly. And it will also create a cause of action so that those harmed by Canadian companies or their subsidiaries operating anywhere in the world can file suit in Canadian courts. Now, I think we all recognize that, legal action is still a tricky path for many people, but at least it allows people who are having trouble accessing courts in their own countries to come directly to Canada through a cause of action in the legislation. So I think what I've been asked to talk about a little bit is, so how does these efforts of national civil society organizations, such as in Canada or in Europe, for national legislation, how does that interact with the efforts to create a global treaty? And I would say that both the global push for the treaty and national efforts in countries such as Canada and Europe to create national mandatory human rights and environmental due diligence legislation, they both demonstrate the global concerns that rules and enforcement for businesses are required. National mandatory human rights and environmental due diligence laws will only apply to parent companies that are based in the countries that create this legislation. So far, there's only one country that has managed to actually create this legislation, and that's France. The others are still efforts that are underway. Whereas the treaty will apply globally to all corporations. So a strong treaty will help justify the need for mandatory human rights and environmental due diligence legislation in individual countries, and more national mandatory and human rights environmental due diligence laws in individual countries will help reinforce the need for a strong treaty. That's what we're hoping, those of us who are working really on both to some extent. So I'll just leave it there.
Thanks so much, Catherine. And to the audience, if there are any questions that you would like the panelists to address, please feel free to write them into the Q&A. We have a few comments, and I believe we had one question in particular in terms of the text on the rights of victims and how to draw jurisdiction and liability upon states and TNCs. I don't know if any of the panelists would like to answer that specifically. Pedro, I also know that you had one more recommendation that you were going to give, and you kind of ran out of time. So if you would also like to address that now, please feel free.
I think it's fine, Maria. Thank you very much. This was related to another subject.
Well, if there aren't any questions, I'm going to go to, sorry. One just came to Marcos. What are the main challenges to have reliable scientific studies of samples to determine levels of contamination? The ones available are either captured by the companies or very expensive to be accessible for the victims to preserve the chain of custody. Is there any way to breach that gap, or any specific recommendations on this? And I think, you know, kind of to add to that, I thought it was interesting your point on mercenary scientists. So kind of the balance between the two of the gap of individuals and then the experts that companies employ.
Thanks, Marya. So a couple thoughts here. One is that sorry, I'm going to turn on my video. Okay, now there's a technical problem. Sorry about that. I don't know what's happening, but maybe you can hear me?
Yes, we can hear you well.
Okay. So first point there is that in regards to the burden of proof, so if there's a transfer of the burden of proof or dynamic burden of proof, this question of establishing through evidence causation of exposures to toxic substances to the exclusion of other causes. So this is the preponderance of the evidence, and there's also the precaution principle as has been used in litigation successfully in some parts. Those formulas could help in this regard. That's one aspect. A second aspect is that at times the evidence has come from government sources. Now that is tough in the sense that the scientific reports of the government, they are not always disclosed, so there's an access to information issue there, or they are not reliable either. They have been tampered with because of corruption or otherwise. But where they do exist, they also provide a formula and a tool to address the limitations and difficulties here. So those are a couple reactions on this point. I would point out that indeed the lab work required to draw toxic analysis is expensive, and that's where not just government reports should be available, but there should be in the treaty abilities for building capacity and for, again, mutual assistance in dealing with that. So that's a point. If I could also reflect on another point, which is on class action lawsuits in terms of adequate reparations, including on compensation. The draft addresses class action lawsuits explicitly in its Article 4.2 letter D. It talks about class action in appropriate cases, and that leaves me wondering which are those appropriate cases, and that there's a lot of possible flexibility there for parties, and that may be a positive thing as well. But it would be useful, I would say, for the draft to further elaborate on what are appropriate cases. And I say this because the process of identifying the victims can be challenging, especially where there are thousands of possible victims. We have seen instances that have been described as the commodification of victimhood, where criminal gangs have been set up to extort victims' money in the expectation of a compensation judgment. And so having an orderly process for identifying victims and for the filing of claims can begin to address that concern, in addition to the points that I would say, again, echo what Pedro has put on the table in terms of the competing litigations and the pressure that puts and the risks of uncertainties. So there could be further elaboration in that provision of what are appropriate cases and specific rules that could be laid down in order to avoid the kinds of issues that have been identified by the panel today. So I'll stop there and I'll try to see what's happening with my camera.
Thanks so much, Marcos. Since we're nearing the end of the hour and it's also very late for Elizabeth, I just want to provide an opportunity for last comments from all of the panelists as well as Catherine. So we can start with Pedro, if you have any final thoughts.
Yeah, regarding the question regarding the scientific studies and the burden of proof, what I can contribute is the recent agreement between Vale and the Brazilian Public Attorney Office, which I have quoted in my presentation. It is interesting that this agreement has replaced the scientific studies that were being carried out by judicial experts and has replaced them by scientific studies that will be carried out by the perpetrator corporation or by companies directly related to them. So one of them, this for me is one of the major problems of this reparation agreement of the Vale Corporation this year, because until this agreement, we had judicial experts, independent experts that would assess the damages, serving the judge of the case. But now we cannot completely trust the studies that will be carried out by the corporation. So this was another of the problems of this agreement. It has made the studies of the damages in this case more unreliable in this case.
Thanks, Pedro. And also at the beginning of your intervention, you had mentioned the architecture of impunity. And I was wondering if there's going to be a report specifically that will be coming out and if there's a time that we can keep our eye out for it.
Yes, actually, with Rodrigo Pereira, we are actually writing this report, which is entitled Architecture of Impunity. which analyzes both of these cases, the Mariana and Brumadinho case. It will probably be published on, not be published, but will be finished on the next month. And we hope that until December, we can have this report published.
Great, thank you. We look forward to seeing that. Elizabeth, do you have any final thoughts?
Thank you very much for this opportunity to join in this event. And as what I have said, justice for the mining victims in Marinduque has been elusive. And I hope that this new mechanism, the legally binding treaty, could help us to make the mining company take on their responsibility and accountability for the damages that have done in the province of Marinduque in the Philippines. So thank you very much for the opportunity.
Thank you, Elizabeth, and thank you so much for also being willing to participate with the very challenging time difference. Marcos, do you have any final thoughts?
Thanks. One final thought is on actual remedies and how the draft could further elaborate on compensation and restoration. It's often argued that, or said that compensation can be seen as an expression of the polluter pays principle, but this has often been used to advance impunity because monetary damages may not be adequate to offer effective remedies and reparations to the victims of environmental harm. This is especially so for indigenous peoples in their close relationship with their lands, territories, and natural resources. So when it comes to environmental issues and restoration, it's not that the polluter pays, but that the polluter cleans up and restores the environment to the condition that it existed previously. That's one point. And secondly, on fines and criminal responsibility, so often incorporated, fines are often incorporated in the costs of doing business. Governments sometimes portray them as saying this is the biggest fine levied on a corporation in the history of our judicial system, where in fact the fine may be actual peanuts, just a day worth of profit for some giant corporations. That's where criminal responsibility should also be clearly established in the treaty. I think the draft makes a lot of progress in that. Of course, it needs to be translated into internal law, but that's a big element of the picture of ending impunity and actual remedies. So thank you very much for the opportunity, the space to join the panel, and for the very rich discussion.
Thanks so much, Marcos, for your participation and comments. Catherine, do you have any final thoughts?
Yeah, just maybe just a thought around the fact that we probably need more discussions around the efforts of civil society to create national legislation that will hold their parent companies and all of their subsidiaries and business relations globally to account in the parent company versus the effort to do the treaty. These should not be, things that divert energy. They should be supporting each other and enhancing each other. But I think sometimes that those of us involved in the national legislation effort don't have enough time to also be involved in the treaty. And people involved in the treaty don't necessarily know about the work that's going on to create national laws to hold companies to account at home, particularly in Europe and in North America and Australia, starting to look at this kind of legislation as well. So I really appreciate the fact that we were able to do some cross-fertilization here, and that I think we're going to need to keep doing that as the work on the treaty continues. Thank you.
Thanks, Catherine. And yeah, I definitely agree. I wish we had more time. The discussion today was very interesting. It'll be very useful for us as we move forward with the negotiations this week to think about the points that all of the panelists made and hopefully have them included in the next draft of the LBI. So thank you again for joining us today, and we'll be reaching out probably soon with a recording of this event. Thanks to everyone.